everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we will be dealing with the important questions of the administrative law, right? So in administrative law, for you, the most important part will be the natural justice part, right? If you are well versed with the principles of natural justice, then I think you have covered enough, right? So we will be dealing with all the important questions today. So let's start. Before I start, I would like to tell you that EduTap has come up with test series for both the phases, phase 1 and phase 2. It will be very helpful for your revision. It will include chapter-wise tests, sectional tests and full-length tests. We have also come up with live crash course and the live classes, they are already going on. So it is for both the phases, phase 1 and phase 2. It has live classes I've told you, and it also includes the test series that I just mentioned, and you also get one-on-one mentor support. So if any one of you is interested, can refer to the link in the description below. Now let's start. Question number 1. Administrative law is a law concerning the powers and procedures of administrative agencies, including especially the law governing judicial review of administrative action. This definition was given by who? So the answer to this is option B, that is K.C. David, right? So K.C. David gave this definition. I will read it again. Administrative law as the law concerns the powers and the procedures of administrative agencies, including especially the law governing judicial review of administrative action. Question number 2. Which of the following is not a principle of rule of law according to A.V. Dicey? Supremacy of law, equality before law, predominance of legal spirit, or wide discriminatory powers? So, according to the theory of A.V. Dicey, the rule of law, which of these is not included in the rule of law? The answer is fourth. The fourth one is correct. That is the wide discretionary powers, right? So, the principles proposed by A.V. Dicey, they were absolute supremacy of law, that is our law is supreme, equality before law, that everyone is subject to one law, and the predominance of legal spirit. Question number 3. Which of the following is correct definition of audi alterum patrum? Listening to the appeal, right of fair hearing, right to know reasons of decision. So the answer is B, that is right of fair hearing. So what does audi alterum patrum mean? It means the right of fair hearing, right? So audi alterum patrum is a Latin phrase meaning listen to the other side or let the other side be heard as well. So you must have heard about this, that no one should be condemned without being heard, right? So this is with consonance of this principle, right? It is the principle that no person should be judged without a fair hearing, in which each party is given the opportunity to respond to the evidence against him. So everybody has to be given an opportunity. They have to be given an opportunity to defend themselves, right? So this is what this is, the right of fair hearing. Further, it has two other principles. The first one is notice, that the other party should have the notice of such proceedings, and the other one being hearing, right? So the right of fair hearing or the alterum patrum. Question number 4. Which of the following are essential principles of natural justice? Justice should not only be done but seem to be done. One cannot be a judge in his own case. No party should be condemned unheard. Impartial hearing must be extended to the person against whom a charge is framed to the state in case. So the answer is option C, that is all of these, they are correct. The principles of natural justice, they are not defined in any statute, but they are accepted and they are enforced. In practical terms, the essential principles of natural justice, they are: justice should not only be done, but it should be seen to be done. One cannot be a judge in his own case. No party should be condemned unheard. Impartial hearing must be extended to the person against whom a charge is framed to state his case. And final decision should be by way of speaking order. I have discussed this earlier, that what is a speaking order. For such an order prevents any bias or prejudice creeping into the decision. So these are all the principles of natural justice. Question number 5. When the court declares that certain provisions of the act as invalid, it does not affect the validity of the act and it remains as it is. So this principle is known as doctrine of swearability, right? So the doctrine of swearability means that when some particular provisions of a statute offends or is against a constitutional limitation, if they are beyond the constitutional limitation, but the provision is swearable from the rest of the statute, that is that it can be cut down and the rest of the statute, it stands on its own independent footing, only that offending provision will be declared void by the court and not the entire statute. So you must have read about this doctrine in the constitution in article 13. So the doctrine of swearability. So the doctrine of swearability means that when some particular provision of a statute offends or is against the constitutional limitation, but that provision is swearable from the rest of the statute, only that offending provision will be declared void by the court and not the entire statute. Question number 6. Delegated legislation is also known as. So the answer to this question is E, that is all of these are correct. Secondary legislation, subordinate legislation and subsidiary legislation. Delegated legislation, they are also referred to as secondary legislation, subordinate legislation or subsidiary legislation, is law made by an executive authority. So when the parliament delegates its powers to the executive body, right, then it is known as what? It is known as delegated legislation. Is law made by executive authority under powers given to them by primary legislation, that is the parliament, in order to implement and administer the requirements of the primary legislation, right? So when the law making body, they are giving that authority to the executive body, then it is termed as that law that the executive body is making. So that is what? That is delegated legislation. Question number 7. The principles of natural justice apply. Your options are administrative proceedings, quasi-judicial proceedings, judicial proceedings. The answer is all of above. So the answer is all of these. The principles of natural justice, they are applicable to all of these proceedings. Natural justice is a concept of common law and represents higher procedural principles developed by the courts, which every judicial, quasi-judicial and administrative agency must follow while taking any decision adversely affecting the rights of a private individual. Next question, question number 8. Which of the following statement is incorrect? The principle of audi alteram patrum is the basic concept of the principle of natural justice. The principles of natural justice also apply to administrative proceedings. Right to speedy trial is implicit in the Article 14 of the Constitution. The concept of natural justice is to prevent miscarriage of justice. Accused has fundamental right to know the grounds of his arrest, right to legal aid in case he is indigent, right to consult his lawyer and such other rights guaranteed by Constitution and equivalent safeguards incorporated in CRPC. So the answer is option C. It is not Article 14 but Article 21, right? So right to speedy trial is implicit in right to life and liberty guaranteed by Article 21 of the Constitution. So your right to speedy trial and your right to fair trial, they are both envisaged in Article 21 of our Constitution. Question number 9. Which of the following statement is incorrect? The power of judicial review is a constitutional power since it is the Constitution which invests these powers in the Supreme Court and the High Court in the state. Article 32 empowers the Supreme Court to issue directions, orders or writs. Article 226(1) empowers the High Court in the state or the Union territories to issue to any person or authority, including any government within their territories, directions, orders or writs for the enforcement of the fundamental right or for any other purpose. The power of judicial review of the High Court under Article 226 is narrower than the Supreme Court's power under Article 32 of the Constitution, or Article 14 prevents arbitrary decision being vested in the executive. So the right answer is option D, that is the power of judicial review of the High Court is narrower. It is not narrower, it is much wider than the power of the Supreme Court under Article 32. Why is that? Because under Article 32 the Supreme Court can only enforce a fundamental right, but under Article 226 the High Court can enforce any right including the fundamental right and any other legal right. Right, let's read it. So The power of judicial review of the High Court under 226 is wider than the Supreme Court's power under Article 32 of the Constitution. The expression for any other purpose enables the High Court to exercise their power of judicial review for the enforcement of ordinary legal rights which are not fundamental rights. So under 226 you can enforce your fundamental right as well as any other legal right. Question number 10. Supreme Court of India for the first time ruled that Parliament has the power to amend any part of the Constitution but it cannot alter the basic structure of the Constitution in. The answer is Keshav Nanda Bharti case, right? Let's read this. In Keshav Nanda Bharti case, it was a case in 1973. The Supreme Court of India for the first time ruled that the Parliament has the power to amend any part of the Constitution but it cannot alter the basic structure of the Constitution. The constituents of basic structure are not clearly defined by the Supreme Court, but parliamentary democracy, fundamental rights, secularism, federalism, judicial review, etc. they are all held by the courts as the basic structure of Indian Constitution, and the Constitution can be amended but the basic structure it cannot be amended, right? Question number 11. Which legislation provides for the establishment of Lokpal for the Union and Lokayukta for the state? So the answer is Act of 2013, right? So the Lokpal and Lokayukta Act 2013 provides for the establishment of Lokpal for the Union and Lokayukta for state. Question number 12. What is the effect of violation of the rule Audi Altrum Patrum on an administrative action? So the answer is it will be declared as null and void, right? So if the rule of Audi Altrum Patrum is violated, then the decision becomes void. A certain procedure needs to be followed in a rule. A person must be given full opportunity to defend himself. Nobody will condemn without being heard. If the rule is violated, an order becomes null and void. So if this rule is violated, if the party is not given fair hearing, then in that case, the decision will be null and void, right? Question number 13. The institution of ombudsman originated in 1809 in, the answer is Sweden, right? So it originated in Sweden. The concept of ombudsman at first originated in Sweden in 1809. The meaning of ombudsman is an official appointed to investigate individuals' complaints against maladministration, especially that of public authority. So it originated in Sweden, and what does it mean? It is a grievances man, right? It hears grievances from the individuals against the public authority, against their administration, against their maladministration, right? So the meaning of ombudsman is an official appointed to investigate individuals' complaint against maladministration, especially that of public authority. Question number 14. Abuse of discretion can be through malafide, improper purpose, leaving out relevant consideration. All of these are correct. So the answer is option D, that is 1, 2 and 3. Abuse or improper exercise of discretion includes such things as taking irrelevant considerations into account, acting for improper purpose, asking wrong questions, acting in wrong faith, neglecting to take into consideration relevant factors, acting unreasonably, etc. Question number 15. Which of the following statement is correct with respect to Article 14? Equality is authentic to arbitrariness. Article 14 strikes as arbitrariness in state action and ensures fairness and equality to treatment. Right to equality affords protection not only against discretionary law passed by legislature but also prevents arbitrary discretion being vested in the executive. The answer is D, that is all of these statements, they are correct, right? Article 14 prevents discretion being vested in the executive. Equality is authentic to arbitrariness. Article 14 strikes at arbitrariness in the state action and ensures fairness and equality of treatment. Right to equality affords protection not only against the discretionary law passed by the legislature but also prevents arbitrary discretion being vested in the executive. I hope this is clear. Now, question for achievers. Which of the following is a quasi-judicial function? Determination of citizenship, discriminatory proceedings against students, determination of disqualification of members of the parliament, any order of preventive detention. So you have to comment the right answer below. That was all for today. I hope this was an helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.